Court does call the cases of the people versus Quincy Jones.
APA Rachel McDuffie for the people.
Cameron Dadish on behalf of Mr. Quincy Jones, who is approaching. Can you put it on the record?
Quincy Jones.
All right, he has a new case, you know that.
Yes, Your Honor.
All right. So, Mr. Jones, you have a new case currently, okay? And you're before the court on a complaint that alleges that on or about March 14, 2025, at the location of South Huron in Michigan Avenue in Ypsilanti City, that you did knowingly and intentionally possess less than 25 grams of a mixture containing cocaine. Do you understand that charge? I'm not saying whether or not you did it. I'm saying, do you understand what you were charged, what you're charged with?
Okay,
Do you?
I understand that.
All right. That is a felony punishable by up to 4 years incarceration, $25,000 fine plus court costs. You understand that? Mr. Jones, let me ask you something. If I had you tested right now, you gonna test clean?
For what?
Mr. Allen. Mr. Jones, what's gonna be in your system? Because I can't arraign you if you're under the influence or something.
I know
So you might as well just tell me.
some marijuana
And what else?
probably a little bit of cocaine.
Appropriate bit of cocaine. When did you take that?
Be truthful with you.
Huh?
Yeah, I'm be truthful with you.
Okay, so when did you take the cocaine?
About 2 or 3 days ago, so it ain't on my system yet.
Seriously?
Yeah.
So when's the last time you had any marijuana? You're on something,
Yesterday.
you're on something right now. What are you on? What
What do you mean, like?
the worst thing is to lie to me.
What do you mean? What do you mean, like, on something? Like, what do you mean? Like, did I do something to get today or?
I don't think that's a really hard question.
Oh, I smoked some marijuana last night.
Tell you what, it's real clear to me that you're on something. I'm not going to arraign you on new charges. I'm not going to do anything with these other charges. I'm adjourning all of this over to next week. But right now, on your one case, your bond's revoked, defendant's remanded.
Thank you, Your Honor. I.
Why?
You can wait till.
Good. That works. And I'm gonna set that for the fifth. Court does call the case, People versus Elliott Kazan.
Christina, they're here for the people.
Wow. How'd you get over there? What, did they kick you out over there?
No, Your Honor.
So why are you over there?
I'm with Ms. Lundy, Your Honor.
Why is she?
There's a lot of us.
There are, this place is packed with prosecutors.
For the record, Your Honor, Joe Simon, on behalf of Mr. Kazan, state your name, Elliot.
Elliot Kazan.
I'm presuming you have the violation.
Yes, Your Honor. We,
Why don't you approach?
yes, that's what we're going to ask. Thank you. Apologize, what takes? Okay.
All right. In this case, we do have a bond violation report, which indicates numerous missed tests. But then makeup tests were negative for alcohol for a late test, with the exception of the 24th, at which point there was a missed test, retested, and showed up with alcohol in the system.
Your Honor, I've discussed these issues with Mr. Kazan. He's going to admit to the court to consuming alcohol. I don't know if it was the 23rd segue into the 24th, but whichever that day, in violation of his bond, he's going to not try to deny it. He's going to claim full responsibility. We have some requests as a result of that, but first, I think that he's ready to address his.
And that's correct, sir. You admit to this violation?
Yes, Your Honor.
I will not take his plea today. I will adjourn the probable cause conference out to June 5th. 2025 at 9 a.m. And what did you want to say before I sent him?
Your Honor, my client has been screened and assessed with Matthew Statman. That's the provider that the remand court uses. He has made arrangements for his recommended outpatient treatment. It took a while due to backlog, but he's pushed it up and he's got, if the court would permit him, 9 a.m. tomorrow at UMATS, which is the University of Michigan Alcohol Treatment Services or something like that, or I can't remember the full acronym. Anyway, at 9 a.m. is his intake. Additionally, I told him that continued SoberLink testing is not recommended for him, that even though it's summertime, scrams can be uncomfortable, particularly when we stop wearing long pants necessarily, et cetera. That would be the only thing that the court might entertain in terms of making sure he's not a risk to others or a danger to himself. He said he would happily do that immediately, turn in his SoberLink and put on a scram and wear that. So that is our request, Your Honor. I told my client that the court in this situation typically revokes somebody's freedom, revokes their bond and incarcerate them. He's prepared for that eventuality, but hopes the court will consider our request, our alternative request.
The court looking at it, and we had been to conference about this, I think, when I looked through and there's a missed test. I also am concerned with the fact of the blood alcohol level at a 10 o'clock a.m. testing, which tells me that there's probably a whole lot more going on because he had previously missed the other, or had missed the testing at 7 a.m. So when I look at it all, that seems to me to be a big problem in terms of a gap. And I think there was a lot more alcohol consumed than what this one PBT indicates. At this time, given that the defendant has admitted to the violations and violated his bond, the court is going to revoke the defendant's bond. Defendant's remanded to the Washington County Jail. So we'll see next. Court calls the case People versus Larzell, Washington.
APA Richard McDuffie for the people.
Good morning, Your Honor. Edward Drukas on behalf of Larzell, Washington. Approaching.
Your name, sir?
Larzell, Washington.
Thank you.
Sir.
The court has before the plea form. Is that what we're doing today?
Yes, Your Honor.
The plea form indicates that the defendant would be pleading no contest to the charge of receipt and concealment of stolen property, 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct?
That's right.
That's correct, Your Honor.
And you have him sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Larzell O'Neill, Washington.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of receipt, concealment of stolen property, $200 to $1,000. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, sir.
Basis for the no contest plea?
Civil liability.
Sir, to that charge, how do you plead?
Guilty, sir. No contents.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct? Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe, well, I won't ask you that. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 2462111. Any objection to the court having reviewed that report?
And for the people.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt. Counsel, have I complied with the court?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count two. Count one is dismissed. July 3rd, 2025, 10 a.m. before Judge Washington.
If I may address bond, Your Honor.
Go ahead.
Mr. Washington previously was remanded for, or I had been picked up for a warrant for failing to show up to court. I have had several discussions with him, gone over this case, gone over what happened at his sentencing. He did interview with the recovery court. And now with him going to 14B for sentencing, I'm going to assist him with getting the paperwork ready for probation. He knows he needs to make and keep an appointment with probation. We're not objecting to any additional orders the court would impose. If the court would require him to test at community corrections, he would abide by that. He reports to the court today that he would show up to that sentencing, that he's tired of being tired, and he wants to take care of this. So we're asking for a PR bond. He has spent about 30 to 40 days in jail since he was picked up. And I think he understands the consequences of him not showing up to court, and the fact that this was reduced from a serious felony to a misdemeanor. We're asking for that reduction to a PR bond.
Response from the people.
Thank you, Your Honor. So my only requirements for the reduction in this case was that Mr. Washington participate honestly in the screening and referral process for the treatment court. I believe the court had the outcome of that screening interview. I don't have the full assessment report, but I wanted to get some sense of where he is. I have not taken a position on him being released thus far. The only request that I have is that he be ordered to test for drugs and drugs, specifically alcohol, I suppose optional. Especially given the outcome of the interview, Mr. Washington is very adamant about not participating in treatment court, so I do want to ensure that he at least remains compliant.
Yes. Bond will be reduced to a $25,000 personal recovery since defendant to test 2 times per week at community corrections. You understand that, sir?
Oh, yes, sir. And thank you, Justice.
Well, don't show up. I don't know. Judge Washington would be so generous.
I'm gonna show
up.
Sure, sir.
All right.
Thank you.
You got to make sure that you test.